out to a certain degree as far as Dr. Wright's, his effect to his income. So he did say that, but I don't think he fully weighed that entirely, because Dr. Wright, as we know, based on the record, just had a baby. And so he is, I would think, one of the main breadwinner in this case, taking away his ability to go ahead into practice for the rest of his life in Florida, which both him and his wife now are practicing, I believe, correct me if I'm wrong, in Florida. So they are established members in the community. They had no other discipline in New York. They have no discipline in Florida other than this case over in here. That there are facts that are questionable in my mind in the case, especially with a control call. I know if a patient had called me upset, and regardless of what, I'd be apologizing right up one end and up down the other, because I don't want somebody upset. But as soon as I think Dr. Wright got a whiff of where this call was going, he says, "Wait," and he put the brakes on it as far as that was concerned. I think he was just attempting to do the right thing. So I think these are factors where I would go ahead and recommend to reject the administrative law judge his legal finding and his interpretation of law as it relates to Chapter 460 and 64B2 on what this board has done in the past. So that would be my motion to reject the penalty.
The penalty. Do we have a second? I'll second, because I agree that revocation is excessive based on our previous rulings for even more egregious situations. And, the he said, she said nature of this, certainly, even though I feel like the patient's testimony was very credible, removing Dr. Wright from his community and taking away his lifelong ability to earn a wage, I think is more than what we would usually penalize. But we do need to protect the public. And so that's why I would speak as a second to the motion. Does anybody else want to say anything? Board members, regarding the motion? We'll call the question then. I'm a yay for rejecting the penalty. Dr. Fox is recused. Dr. Fogarty?
Yes.
Dr. Hunt? Dr. Hunt, I can't hear you. Say again, please. I'm sorry, I can't hear you. Mr. Harris, can she text me or vote?
No, she cannot. Well, no. I mean, if she texts you, I guess we could read it into the record, but that really wouldn't be okay. But you still do have, let's treat it as if she's dropped off the call. You still have a quorum.
There she is. Hang on. Hang on, I hear you now.
Oh, okay.
Go ahead.
I don't know what happened there. Yes, I agree.
Okay, great. Dr. Weingarten?
Yes.
Ms. Saunders?
Yes.
So motion carries. We're rejecting the penalty. And would you like to offer a counter option for a penalty, Dr. Fogarty?
I would.
I see your hand up.
Along the lines of what I was already speaking about, let us offer a counter penalty of the National Board EBAS exam, ethics and boundaries, taken and passed within a 1-year period of time. that he must have a female chaperone with him when he's alone with a female patient for 5 years. And then that female chaperone has to be registered with the board and sign the affidavit, which we've used in the past. Additional continuing education should be completed beyond his the biennium, which includes Florida laws and rules for 2 hours, additional ethics for 2 hours, additional risk management 1 hour, community service. I would do 100 hours within a 5-year period where the doctor is able to volunteer, you know, in the community that he's serving right now, and then a fine of $2,000 to be paid in 5 years, $1,000 per count.
This is Dr. Hunt. I will second that.
We have a first and a second. Ms. Garrison?
Yes, thank you. If I can be heard before the board makes their decision on this discipline, I would just like to note that, and as understandably noted by the administrative law judge, that they found that there was no contrition, no remorse. There was a lack of self-awareness by respondent in his actions against this patient. His wife was in the office when he sexually offended this woman against her wishes. His wife was pregnant at the time. He knew he was going to be a father at the time he sexually molested this person. And I know Dr. Fogarty had mentioned that he's the main breadwinner. That is not the case here. It was established well within the record that his wife was the main breadwinner, making 60% of the family in household income. I mean, this woman did not ask for this. We would not be here today if it weren't for the actions of the respondent offending against the bodily anatomy of another person by inserting a tool in her vagina. I mean, I really think that the board should weigh heavily on the offense that has taken against this person in a sexual manner. It was not asked for while he was acting in a professional atmosphere as per chiropractor. The recommendation is from the administrative law judge to revoke this license. This was from someone who worked as a defense counsel making this recommendation. I think the board should weigh heavily the fact that he has been offended against in a sexual manner, that he had no acceptance of responsibility in his actions and still takes no responsibility. The board should weigh heavily. I don't know why there should be a 5-year restriction on having a female chaperone if that's what the board is going to move forward. It should be a permanent restriction if that's how the board is moving forward on this discipline. If you read the discipline guidelines on 460.412, it reads that the minimum discipline guidelines require a 1-year suspension. I think the board should take that into consideration and consider suspension as a portion of the discipline here if that's how you are moving forward. I just ask that you heavily consider the facts of this case and what has been found in what you are considering for the discipline of this respondent.
And